In what is sure to be a crippling blow for critical race theory advocates, a recent decision in the U.S. Fifth Circuit Court of Appeals tested CRT and found it unconstitutional. Judge James C. Ho wrote an observation of the court's decision to deny that racism had occurred on behalf of the accused. Quote, "There's a big difference between prohibiting racial discrimination and endorsing disparate impact theory. It's the difference between securing equality of opportunity regardless of race and guaranteeing equality of outcome based on race. It's the difference between colorblindness and critical race theory." But before we get into that, let me give you some background on the case. This is the court document itself that the decision came from. According to the legal document, the story goes like this. In the city of Freeport, Texas, the Port Authority was cooperating with the U.S. Army Corps of Engineers on planning and executing the Freeport Harbor Channel Improvement Project. This project was designed to improve the Freeport Harbor Channel while also expanding the size of the navigation district into the Velasco Terminal. To do this, the Port Authority needed to acquire more land in the East End Velasco Terminal area adjacent to Port Freeport, and thus began a program to acquire property in the East End. An African-American man named Manning Rollerson contended that the Port Authority was using coercive and illegal means to force homeowners to sell or vacate their properties, such as threatening them with condemnation and eminent domain, or telling residents that there were liens on their homes that did not exist. Then, Rollerson took it a step further and amended his original statement to include the accusation of racism. Rollerson accused the Port Authority of having acted in a discriminatory and racist manner against the residents of the East End property which they were attempting to acquire. As it turns out, making the accusation of racism against the Port Authority may have been a mistake, because after said race card was pulled, it was on Rollerson and his lawyers to prove that discrimination had occurred. Only there was one big problem for Rollerson and his lawyers. There was no evidence that the Port Authority had acted in a racist or discriminatory manner in their attempt to acquire property in the Velasco district. So Rollerson's legal team changed tactics. Instead of accusing the Port Authority of intentional discrimination against the African American and Latino residents of the East End area, they accused the Port Authority of unintentional discrimination instead. Using a legal term which comes directly from the philosophy of critical race theory called disparate impact, Rollerson's team alleged that even if the Port Authority had not intentionally acted in a discriminatory way, their expansion project was still racist because their actions disproportionately affected the minority population of the Velasco district more than it affected white people. The court, of course, found this argument preposterous. The judges reviewing the case recognized that the Port Authority could only expand in one direction because the property adjacent to Port Freeport was the only available property. Edith H. Jones, American Circuit Court judge, writes, "I would find Rollerson's theory of intentional discrimination wholly wanting on its face. The harbor channel's location is fixed. Any expansion of the channel must be along or within that fixed course. The Velasco terminal's location is also fixed. Therefore, unless there is real estate other than the East End into which the terminal could expand, it is impossible to attribute intentional discrimination to the choice of where to expand. There is no suggestion in the plaintiff's complaint of any other possible area in which the Velasco terminal could have expanded. Geography, not discrimination of any kind, lies behind the port's decision about location." Here is where the lofty ideological waves of critical race theory, which asserts that racism is always present in every system, political decision, and social interaction, and in fact in every single facet of our lives, crashes into the craggy shoals of reality. American Circuit Judge James C. Ho writes, "Congress enacted Title VI of the Civil Rights Act of 1964 to prohibit intentional racial discrimination, not to restrict neutral policies untainted by racial intent that happen to lead to racially disproportionate outcomes." There's a big difference between prohibiting racial discrimination and endorsing disparate impact theory. It's the difference between securing equality of opportunity regardless of race and guaranteeing equality of outcome based on race. It's the difference between color blindness and critical race theory. Compare Martin Luther King's "I Have a Dream" speech With Ibram X. Kendi's "A racist policy is any measure that produces or sustains racial inequity between racial groups." Prohibiting racial discrimination means we must be blind to race. Disparate impact theory requires the opposite. It forces us to look at race, to check for racial imbalance, and then decide what steps must be taken to advance some people at the expense of other people based on their race. But racial balancing is, of course, patently unconstitutional. Disparate impact theory must be justified, if it can be at all, as nothing more than a legal presumption that evidence of racial imbalance is evidence of racial discrimination, at least until the defendant can prove otherwise. But a presumption of discrimination runs into a bedrock principle of our legal system. We ordinarily assume innocence, not bigotry. Plaintiffs must typically prove, not presume, discrimination. Moreover, opponents of disparate impact theory worry that it will only exacerbate rather than alleviate racial tension by pressuring defendants to adopt policy changes for the explicit purpose of taking from some and giving to others based on their race. They fear that disparate impact theory means not only presuming discrimination, but actually requiring it. A former Justice Department official, Roger Clegg, offered the following illustration of this concern. Quote, "If a bigoted Los Angeles employer determined that he had been hiring too many Asians and Jews by giving them a particular test, and therefore deliberately discarded the test for one that he knows will result in fewer of them being hired, all would agree that this violates the law. And yet, it is precisely this kind of calculation that disparate impact theory applauds." The illustration turned out to be prescient. The Supreme Court confronted that very fact pattern a few years later. The court there noted that, quote, "all the evidence demonstrated that the city chose not to certify the examination results because of the statistical disparity based on race. The city rejected the test results because too many whites and not enough minorities would be promoted were the list to be certified." The court made two observations about the city's conduct that are no doubt troubling to disparate impact opponents. First, the city's decision to set aside the exam results out of fear of disparate impact liability resulted in racial discrimination against those who succeeded on the exam, precisely as Clegg predicted. Second, this racial discrimination would be perfectly permissible as a matter of disparate impact law, so long as there is a, quote, "strong basis in evidence that it was necessary to avoid disparate impact liability." So these are not frivolous concerns of discrimination that we're talking about here. In fact, for disparate impact advocates, requiring discrimination may not be a problem. It may be the whole point. To quote one leading critical race theorist, "the only remedy to past discrimination is present discrimination, and the only remedy to present discrimination is future discrimination." It's hard to imagine an area where we should be more wary of vesting discretion in public officials than race. Our nation's history is replete with tragic lessons in this regard. We have learned the hard way to distrust those who claim they're using race for benevolent rather than nefarious ends. So public officials may sincerely believe that race-conscious policies are beneficial rather than corrosive, but the American people have never been the blindly trusting sort. Citizens may fairly wonder how officials can condemn race-neutral policies as racist and defend explicitly race-conscious programs as inclusive. Citizens are understandably skeptical when government officials claim that they're just here to help, but then declare that up is down, left is right, race consciousness is good, and race neutrality is bad. It's said that the road to hell is paved with good intentions. That's why we have laws on the books, like Title VI, that simply forbid the sordid business of divvying us up by race, no matter what our intentions.
Tell the mobs in front of the courthouses to go home. We got this. The American constitutional order has got this. We can trust the outcome of the deliberative processes of our legal institutions. We got this. They are not the embodiment of white supremacy. It's okay. We are no longer in the 19th century. Chill. Black people are basically equal citizens of the greatest republic in the history of the planet. Now, let us man up to our responsibilities as citizens rather than belly aching about every little microaggressive inconvenience.
Never. Never. And that's the problem. What you just said will be considered heresy until we are both not alive and beyond.
Well, God help us then, help us, the United States of America, because if riots break out across this country again in the spring and summer of 2021, as they did last year, we'll be on a slippery slope to hell. I'm talking about the American Republic. That's how high the stakes are here.
Final thoughts. If critical race theory, which began as a legal theory to redress racial disparities in America, can't even stand up in American courts, that's telling us something, isn't it? If it's not even valuable in a court of law, it certainly has no place being taught in our classrooms. Thank you for watching.